Good afternoon, everyone. Welcome to the Beverly Hills Bar Association Startup Law Initiative, which is a series of programs geared toward entrepreneurs and startup founders. This series is divided into two parts. Part one consists of programs on overview of the startup process, entity choice, protecting intellectual property, and employment issues. This is the program on entity choice. Please note for your calendar that the program on protecting IP is scheduled for June 20th and the program on employment issues is scheduled for July 11th. Throughout these programs, questions are welcome and encouraged. If questions in another practice area come up, do not fear. Please check out another class in this module. Also, we're planning a website page soon where you will be able to find materials as well. With that, now to our program on selection and organization of the business entity. I'm Levon Lawson, and it is a pleasure to introduce our speakers. A few words. Leighton Pace is a tax and corporate law attorney. He provides tax and tax-related legal advice to sophisticated business and real estate clients, fiduciaries, and law and accounting firms of various sizes with complex transactions, structuring, and tax controversy needs. Bill Staley is a corporate and tax law attorney. Primary areas of practice include tax planning and general business law for closely held businesses and nonprofit organizations, structuring, negotiating, and documenting business deals, advising attorneys and accountants concerning high stake tax issues, and business succession planning. Income, estate and gift, property tax issues, restructuring businesses, and designing incentive plans for management are all a part of this planning. Bill Norman is an international tax attorney with firm Norman & Zang, which engages in different general business and tax practice representing partnerships, joint ventures, private investment funds, and individual entrepreneurs concerning day-to-day operations and cross-border transactions, including acquisitions and restructurings. That's just a little bit. There's a lot more, and you can read more about our speakers at their bios in the program materials. With that, I'd like to turn this over to our speakers. Again, welcome and thank you.
Okay, thanks, Levon. As Levon mentioned, this is the first of three, I would say, technical webinars in part one of our startup law initiative. The first one, in which I assume most of you attended, was a kind of overview of the whole area. And now we're going to dig in more deeply into three topics, or four topics actually, two tonight, and then intellectual property and employment law to follow in the scheduled weeks that we have. We've asked all of our panelists to keep in mind our audience, our principal audience, which are entrepreneurs and advisors to startup enterprises, and to focus on the practical aspects as opposed to the maybe highly technical aspects of startup law itself. And don't be concerned about the amount of material, because once the decision is made, and we have 7 questions here, much of the technical material becomes no longer relevant. For example, if you choose to establish an LLC as your entity of choice, then the intricacies of S corporations and C corporations become largely irrelevant. We've made it clear that the questions are encouraged. In other words, if we're not answering your questions, that our questions are not enough, then be sure to ask questions. Until 5 o'clock, we want to give priority to our fellows, that is the entrepreneurs and founders. And after 5 o'clock, all the other attendees are free to put their questions in. We will be pausing from time to time to consider questions in the chat box. There'll be some interruptions between the various panelists. We're not being rude. It's just the way we planned it, that there will be some commentary, though we may have to sometimes cut it off to keep moving on our schedule. If the questions remain at 6 o'clock and people are still with us, we'll give another 15 minutes to clear up the questions. We're planning to put together some virtual office hours for our speakers, the previous panel and this panel today. The office hours are not establishing an attorney-client privilege, but like in graduate and undergraduate university courses, you can come in and ask your questions privately if you wish. And we ask you to send your questions in advance so they get assigned to the appropriate speakers. So with that, let's go into the agenda, which is up there. First questions up there on the slide deck here. There's points underneath, but those will be covered in the subsequent discussion. So the first question is, why should you, as a startup, even organize a legal entity? Then we'll look at next slide. What are the major categories of legal entities? And then what are the differences between the various entities? Then seem to be behind here. Slide's not moving. This is
you want to go?
Yeah, we should go to. Should not go to 4, but we did make major differences. Now we go to the next one, please. Okay, then what jurisdiction? It's not necessarily California. There are numbers of startups that are in other jurisdictions, some of which we've listed here on the slide. Then the last set of questions on slide 5, next slide, is when should you organize it? Day one, when you have the idea in your head, or when you start raising money, all kinds of questions here. And then major part of this program at the end here is what are the procedures for organizing a legal entity. We're going to take as an example a Delaware C corporation, although after you get past the first 6 or 7 items, the formation procedures for organization procedures for other types of entities are pretty much the same. I mean, an S corporation, you have an election, for instance, but you don't have with a Delaware C corporation. And then a little bit about how a startup should prepare for due diligence requirements for later stage investors. Investors and acquirers, of course, are going to want to know what the legal status has been of the corporation, and all the documents are in place. And it's important, which is why we have the program, that we have the startup have its kind of legal house in order as much as possible. And there's always a few loose ends, but as much as possible. Okay, with that, let me turn it over to Leighton. Going to take us through the first few questions.
Great, thank you so much. So next slide. Next slide. All right, so if I had to speak on one slide for the entirety of the program, this would be the slide. Because this slide to me is what everyone needs to think about when they're deciding to go into business. To me, this is the business plan. To me, this is the pitch deck. To me, it would be the budget. So the first is, what's the nature of the business to be conducted, which to me it really breaks down usually to like services or products. But products can be broken down further into products that are tangible or intangible. Next is, what are going to be the assets? So do you have assets that are things that you can see, touch, and feel, or are they things that are all intangible? How many people will own the business? To me, is really critical. And when are they going to own it? Are you going to start off with just one person, 2 people, or are you going to have a lot of people all at once? Who will conduct the business? To me, is really critical too. That's like, how many managers do we have? Who's going to be the boss? It seems to me that that's a really big issue for a lot of startups. Who's going to call the shots, and how's it done? Where will it be conducted? Which has a lot to do with choice of jurisdiction. It has to do with critical path or lead times, if you have to get consent or have to, kind of have some groundwork laid down to basically conduct business cross border. How will it be funded? To me, that's a really critical issue. Is it going to need to be funded with equity, debt? Can it generate enough cash to fund itself at a certain point in time? And how much money is going to be needed? So that will dictate a lot about the forms of investments that people make. How will employees and service providers be compensated? To me, incentive compensation, I look at business as really being a marriage of capital and services. And so the question is, how are you going to have your service people be on board and how are they going to have proper incentives to stay there? Next, how do you get a competitive advantage? To me, a lot of that is intellectual property. How do you preserve that? How do you lock up key suppliers? How do you lock up key customers? So, again, it's all back on a critical path. What steps would I take first, second, third, fourth? And then, next, startup losses, which plays heavily into the choice of entity. But certain entities let you take losses sooner than other entities might. And then last, which probably would be the first question I would ask, is if you do really well, how do you expect to get out? Because that also is a really big factor in what kind of entity, what kind of planning is there, and what kinds of returns can you expect?
I might mention, Leighton, that back on the other slide there in your list, just move it back.
Go back one.
Just move it back. Yeah, some of our other webinars, we're going to deal with some of these topics in detail, like intellectual property, for instance. And we're going to have next fall, we're going to have a program on funding and cap tables. And of course, we have an employee program as well. An exit strategy, it's really exit and succession, or even continuation, and we'll have a session on that, the very last one in the fall. So all of these topics can't be covered in great detail, but they do need to be considered up front, which is why you need the whole course to actually effectively use some of this material.
Okay, next slide. So Bill mentioned some of this in his agenda, but these aren't really necessarily any priority order. I mean, raising capital might be number one. If you can't get enough money, you're not going to get off the ground. I always focus on liability protection, though, because liability protection, if you do well, you're going to have people come after you. And so I usually, there's something to fight over. So I'm usually very concerned about the liability issues starting up. Maybe that's because I'm a lawyer, so I should be. Multiple owners also is really critical. If you're going to have many owners, you're going to have some form of structure that provides sufficient management to basically accommodate the various demands of the owners. Same with management structure. How do you plan on making decisions? Who's going to make them? Unlimited duration is something that a lot of entities now provide. It used to be that you would have a term, particularly like partnerships would have a term. It's really critical in terms of having longevity of the entity. So if people do switch over and die or for other reasons, the entity will stay around. Public perception. The fact that if you're starting up, to have some entity means that you're big enough, you're going to do it. You're going to make it. You've made a commitment to do it. So let's go on to the next slide. So these are the various types of entities that we chose to list and to talk about. You've probably heard about them, and I'm going to go through and distinguish the various ones. I think that limited liability partnership is one that, again, you've probably heard about. Lawyers and accountants, not generally for startup businesses, and then other miscellaneous kinds of entities too, including entities formed in foreign countries. We're just not going to talk about them. This is too much. Next slide. So sole proprietorship. It's the one you probably have seen or heard about the most. It's basically a one-person operation. The biggest problem with it, no liability protection. Maybe a second problem is hard to grow it, hard to get money, hard to get other owners, and really a lot of exposure to the operations with employees or whatever else. One of the things about it is it doesn't take anything other than deciding to go into business. So you don't have to do any formal business filings. Now, of course, you may have local business licenses and other things like DBAs, but generally there's no Secretary of State filing in order to form it. And as we talked about previously, it's hard to transition to death because it doesn't have unlimited duration. So when the business owner dies, then it can die too. Of course, the wife can maybe carry it on, or the son, or it can be other succession issues there. So let's go on to the next slide. Sole proprietorships can also raise issues on, it's like the gig economy. Is the person an employee? Is the person an independent contractor? Is the person a partner? It was a really big issue we'll get to a little later on here on qualified business income. It's one of the tax provisions that lets people deduct basically 20% of their business income. And it wouldn't apply if you're an employee, but it would apply for an independent contractor. And so there's a lot of pressure today in determining whether or not the person is appropriately characterized. No entity income taxes. That's another big issue we'll talk about today. It's double taxation. What's the leakage? How many different levels do you get taxed at? Here it's generally taxed to the sole proprietor. But it doesn't prevent there still being other taxes and other compliance issues, 1099 issuance, sales and use taxes, payroll taxes, and you still have a self-employment tax. So even though you might avoid, FICA, things that apply to employees, you still have it at the sole proprietor level. Next slide. So for a startup, that's what our conference is today. When would you use it? I would say you use it when you don't know what you're doing. You basically default into it. You start business before you talk to anybody else. You start having an idea, you start generating revenues and expenses, and then you finally go, it's going to work enough. I'm going to form some kind of an entity. I think it's hard to raise capital. Generally, you're going to have to guarantee everything as a sole proprietor. And I think it's harder. Creditors are more leery about it. And if you bring in other equity investors, now you've stopped being a sole proprietorship. So I think for the takeaway is it might work for the first few months until you're really sure you have a business. But I don't think anybody on this panel would recommend that you do it.
Just one item I might add, Lynn. It's difficult to protect intellectual property because if you have employees, they may be developing their own intellectual property, and it may not be owned by the entrepreneur itself or the proprietor.
That's right. I think securing intellectual property is a critical issue. So if you hire someone, you're gonna have to have an employment agreement. It's gonna have to make it clear who actually owns it, that they're just doing it, really for hire, and that the business owns it. So let's go on to the next slide. Okay, so this is the next entity. This is really just one step up from a sole proprietorship. It's the classic handshake, really just an agreement for two or more people to share profits. But it does have some enhancements that sole proprietorship does not have. It lets people have an agreement. And if the agreement isn't agreed to, the law will provide default provisions so that you still have provisions that deal with the rights of the various partners and third parties with respect to it. Turn this off. Let's go on to the. You'll also see that anybody can be basically a partner. So if you have foreigners, if you have all sorts of partnerships or corps or other partners, they can be partners. So next slide. Like with the sole proprietorship, you have no liability protection. That's a problem. It's actually even worse because you don't even have to yourself hurt somebody or contract to do something. Just by virtue of being a general partner in a general partnership, if the other general partner does something in furtherance of that partnership and hurts somebody, then you can be liable, and it's personal liability. So you're not just losing the business, you're losing your personal bank account, your house, your car, and you didn't do anything except join in a partnership with some other partner that was the general partner in the general partnership. So that's really a drawback. Management rights can be good, it can be bad. It's generally each person, each general partner has a right to participate in management. So it's very decentralized. Everyone gets to basically chime in. You make a lot of decisions that are mutual, and that can be good starting off, where you really want people who are active, and so you want to give them a voice in deciding how it's going to be run. On the other side, it can be bad because you can't make any decisions. It takes too much consensus in order to do it. It can't be quick enough. Too much infighting to do it. So we're on the income tax treatment. General partnership has a pretty simple income tax treatment, except for it does have to file a separate return because it really is a separate legal entity. In California, it avoids having to pay the $800. LLCs have fees too, so it avoids paying those fees. And we'll get into it a little bit later here. With the classification rules, you can have a general partnership that can actually say, for tax purposes, I want to be treated as something different than a partnership. I want to be treated as a C corporation or an S corporation. But as it states here, I don't see it very often. I've basically seen it in Texas and other places where there's been some benefit. So let's go on to the next slide here. Get on time. Again, as I said, they're easy to form. In fact, I think most of the time what happens, people don't even know they have a general partnership. I get so many phone calls and I got 2 or 3 people on the phone and they have this great idea. And guess what? They've already agreed to share profits. And they really do have a general partnership and they don't even know it. So I usually tell them right away to, worry about the liability issues and actually form some other kind of legal entity that we'll go to. And as I said, as I've covered before, decentralized management, I think generally makes it a poor choice for a startup. You can't make any decisions. It takes too long to go forward. So let's go on to the next slide. All right, so now we're on to something that I see more often. I see limited partnerships really in the real property context. I mean, I'm sure other businesses form them. But limited liability companies have, for the most part, succeeded then when it comes to kind of active business. But it requires a filing with the California Secretary of State. And this filing now puts you on record. It then requires you also to have one or more general partners and one or more limited partners. And generally, you have a written partnership agreement. I would always advise you to have a written partnership agreement. The codes, the corporation's codes say that you can have agreements that are oral or implied. But if you do that, you're looking to have litigation about what your terms really are. So I really think you ought to have written agreements. The benefit of a limited partnership over a general partnership is that the limiteds don't have liability by virtue of being an owner. By virtue of being a limited partner, they don't have liability. Now, you can still have liability if you're a limited partner and you also work there, or you're doing other things, or you contributed property in there that was somehow title problems. I mean, you can still have other liability issues as a limited partner. Just the formation doesn't necessarily protect you, but it does protect you from liabilities merely by virtue of being a limited partner. So if your general partner does something wrong, all you can lose is your investment in the partnership. Your house isn't at stake. Your personal bank account's not at stake. The other thing that it does bring into the mix is securities laws, because general partnerships generally don't, because everyone's active. And so it's not really a security because everyone has a voice. So they get to basically govern their own monies. And the same is true of sole partnership. In a limited partnership, now you have securities law issues. So now you're looking for exemptions, small offering exemptions, or California 25(1) and 2F exemptions. So you can move on to the next slide.
So securities law will, again, in the fall, we'll have a program on, or a part of a program on securities law compliance. But the exemption.
Yeah, securities law is really, really critical. And I don't think people gloss over it, but a lot of people depend upon exemptions and need to do more in terms of getting accredited investors and making sure the exemptions are actually met and filings are made.
And a lot of business lawyers know the exemptions of securities law, but they don't know the whole area. So it's not always necessary to have a securities lawyer, but you need a business lawyer who understands the exemptions and what it takes to qualify. Otherwise, the investor can get their money back. SEC can actually impose penalties and injunctions. It can really tie up your whole business. So you don't want to have a.
Absolutely. You don't want that at all. You really have to
The
focus on.
investor can get his money back from the promoter, not from the entrepreneur, not just from the business. So if the promoter ignores the securities laws, it's at the promoter's personal risk, even though they have an entity, a corporation or an LLC or a limited partnership.
Yeah, so I'm running out of time here, so I'm going to kind of skip over. So LLCs came in California in 1994. Basically, 1992 was when they kind of cut a hold in the United States. For the most part, they're better than a limited partnership because all the people, by virtue of being an owner, by being a member, are protected from liability. A limited partnership, a general partner has to still be liable. California, of course, there's certain businesses that require a license in the Business Professions Code that prevent you from being that. I don't think in the startup world, probably much of that limitation applies, but you still have to consider it. Let's go on to the next slide. With management, you can kind of pick whether you want to be member managed, which is like a general partnership, or you can be manager managed, which is like a limited partnership. And the agreement gives great latitude in figuring out what kind of management structure. It can look like a corporation. You can write in who gets to vote on what and what all the meetings are. You can, it's basically free form in contract as to how it's going to be managed. It also has the same security laws issues. Bill, I wanted to at least have you talk just a minute on the Corporate Transparency Act, because it's one of the differences between general partnerships and limited partnerships and LLCs now on the formation. Yeah. Say a word on that?
Sure. In the end of I think it's 2020, there was a law passed as part of the Defense Authorization Act, and it provides, it doesn't have anything related to defense necessarily, but it provides that if you have an entity that is organized under domestic law, meaning a U.S. state or District of Columbia or other territories, or it's registered, if it's some kind of foreign entity that's a Cayman Islands limited partnership that's registered in a U.S. state, then that entity can be a reporting entity unless it meets one of 23 exemptions. The major one is that if you can avoid the reporting if you're more than 20 employees or have more, I think it's more than $5 million of gross receipts in the preceding year. And what it provides is that the reporting company or enterprise has to disclose the individual owners who control or own together or collectively 25% or more of the ownership of the entity. So it requires that, and it applies to existing entities.
Right. They have to report like within a year of the final regs. The upshot is if you're a general partnership, the rules don't apply.
25.
If you're a limited, if you're an LLC or a limited partnership, you have now these new reporting requirements you have to comply with, which is all changes in ownership too. It's not like a one-time filing.
No,
you're constantly now reporting who the owners are of your entity.
If anything changes, including the address, anything that's on the required disclosure for the individual owner or controlling party has to be reported. So it goes on and on. So it's a compliance issue that we'll talk about in the compliance section in the fall. But if somebody's concerned about kind of confidentiality, you're not going to have it. Now it goes to the
unless you're a general partner, right? I mean, that's the reason I wanted to bring it up. So it's like if I had to come up with a plus is why I would want to be a general partnership, it'd be these rules don't apply to me.
If you're a sole proprietorship, you won't have to do it.
Yeah.
But anybody that qualifies to do business or is organized under state law like a limited partnership will have to file this report unless they meet one of the exceptions.
Yep. Okay, so let's go on the next slide because I'm running out of time here. Okay, so taxation of partnerships, I'm hoping not going to scare people away. It's the reason I'm on this part of the program. It's really complicated. Partnership tax in the last 30 years has just gotten amazingly complicated. But the biggest, I think, on the slide is that you can now pretty much pick what kind of tax treatment you want. So even if you're a limited partnership at state law or an LLC at state law, you can be a partnership for tax purposes, or you can be a C Corp, or you can be an S Corporation generally. And so, and you still have to have the governing instruments make sure you're eligible to be that, but it's check the box. And so it makes a lot of tax discussions really complicated, because when you say I'm an LLC, the first question I have is, well, how are you taxed? Because just the fact you're an LLC doesn't mean anything, because you can elect to be taxed in different ways. The biggest takeaway on taxation of partnerships is that the entities themselves do not pay the tax generally. It passes on through to the owners. And so that has, for the most part, reduced overall taxation. It's caused really since the 80s, people to be pass-through entities, because it's cheaper tax-wise to have everything flow through to the owners. And it also enables them to get capital gain treatment. The downside is that they're taxed whether or not the entity gives them any money. And you'll see it comes up later on, because it just flows on through by merely being an owner. If you're a 10% partner or a member of an LLC, you get 10% of the profits, even if you don't see the money ever. And so it's really something that for startup companies can be disadvantageous for joint venture capital, et cetera. On to the next slide. Get the next slide.
I did maybe go back one, and I don't know if I didn't rehearse all this, but I think of one thing I get a lot of questions on, which I'm not really an expert in, and have to refer it out, is carried interest, which is a way for a partner to get a capital gain.
Absolutely. I meant to go to this slide. I meant to go over that, but yes. So let's just go through eligibility. Anybody can be a partner of a partnership for tax purposes. You'll see from S Corps, it can't be. Disproportionate, really a critical factor. You can write in your contract who's going to get what money and what profits at what time, or who's going to get what losses. You can basically, by contract, divvy up all the items. And so it's really popular because you can give every investor class exactly what they want. And you can do things without having to go back and change your charter. You just have a new agreement, an amendment to your agreement. So it's incredibly flexible in terms of deciding how the money goes. The carried interest legislation has been under attack, certainly for like the hedge fund industry. I don't know about general, but it is a key factor. You can give a person a profits interest, not to have them be immediately taxed. So if you've got a key person that wants to be a worker, you can bring him in as a partner, no immediate upfront tax consequences if it's a profits interest. So it's a really key advantage over other businesses. Liabilities is also a key one. Because liabilities get to be added to basis, which generally means that people can claim losses that are funded with debt. And that can reduce, it can increase the present value of the tax flow of the cash flows coming out of the entity. If you get losses, they can use those losses generally to offset other income. And so investors may want this because it helps them tax-wise. Let's go on to the next slide.
Leighton, what about a profits interest? So the profits interest versus capital interest. So if you have a company that's worth $1 million and you bring somebody else in, what is this deal as a profits interest?
That's a really good point. A profits interest has been defined in a revenue procedure as if it liquidated the next instant after it was granted, you would get nothing. It's a liquidation value approach. So if it's $1 million company and you grant 10%, if it's sold the next day, the person is supposed to get $100,000, 10% of the million. That's not a profits interest, because immediately after the grant, the person would get it. That's a capital interest. Capital interest for services are taxed. It's treated just like wages. And so what companies have to do, and what can be a little complicated if you have multiple people coming in at different times, you have to what's called revalue the assets, so that all the gain on the million when the person comes in would all get allocated, and all those monies would go to the existing people. So immediately after the grant, the person would still get zero, because you have already kind of booked up the capital accounts of the other people so that they get all the million, you're 10% still of zero. And so this is an area, again, that has seen regulations that just haven't been finalized. It's got a lot of uncertainty about the existence of this procedure. It's from 1993, and you have to kind of meet those requirements in order to get, certainty about your tax treatment. So I'm going to run out of time here. So I just, one of the other key factors is it's called a 754 election basis step up. Again, it's critical for having people, when they make an investment, they buy an interest, they get to now depreciate and amortize the assets inside the partnership, just as if they bought those assets. You can't do that in a corp, in an S corp or a C corp. And so you can start recovering your investment right away. Restructurings, again, this is key. I see it a lot in real property transactions, but it also in new businesses, you don't really know what businesses are going to take off. You may have more than one. It was like back to bricks and mortar and .com. They wanted to separate out the .com business because that's where all the growth was, in bricks and mortar. They didn't want to do it, and it interfered with financing. If you had an LLC, it was much easier to separate those businesses and keep the same ownership. If you're in a corporate solution, it's really hard to do that. Lastly, there are entity taxes on the LLC. Let's flip to the next slide because I'm out of time here. So what are the partnership startup takeaways?
Well, maybe a minute on the entity tax. You might draw out the point that the limited partnership, you're talking about the $800 annual minimum tax, and with LLC, you're getting up to $11,790, which may be real money to at least early startups. And then if you have an S corporation, you have actually an entity level California tax of 1.5%. All these things have to be kind of modeled out to figure out if it really is significant, for a given entrepreneur.
That's correct. Yeah, the top almost 12,000 is if you have gross receipts over, or gross income over 5 million. So you might reach that level. It is a toll charge. It's still deductible, so you get some tax benefit from the payments. So it's not really out of pocket the full 12 grand, but it's still a factor. Partnership startup takeaways. You've got to have an agreement. You want to put it in writing, particularly if you're going to some jurisdiction like Delaware. They give you so much freedom to write your entire deal, basically whatever you want. But the downside of that is, if you don't write it, what do? They have very few default provisions, and so there are a lot of issues that are uncovered. So I generally think if people who are doing Delaware ought to have longer agreements, how to cover more provisions that the default provisions of other jurisdictions may have. I think the fact that you can have the profits interest is really a key factor. But as we talked about, revaluations of cap, it can be trickier. How do you run a stock option plan in an LLC that's taxed as a partnership? It's harder. The pass-through of losses to partners, as talked about, lets people write things off. The 754 election, again, lets people write things off. And I think the last point is investors, angel and VC investors, they really don't like pass-throughs because there's no assurance of getting any of the money. The items just pass on through to you by virtue of being a partner. And then, so you may have, profits coming through and there's not a corresponding cash payment. And so I think that to me is probably the biggest reason why they don't like them, but there are other reasons too.
I think the reason that I hear anymore anyway is that the angel and VCs are really after growth, rapid growth in value of the company. So an angel investor may want to get 100 times, up to 100 times whatever they invest. because a lot of their investments are going to go bust and not be worth anything. VC is a little less, but it's still talking, 10 or 20 times whatever they've invested. And they're not really concerned about loss pass-throughs and some of the things that might be important on early stage to founders in early stage startups. So they just want that capital growth. And your point here that, when you have a lot of complicated partnership provisions, it's difficult then to put into the agreement, what the share is of the angel or VC investors. I've never seen a VC investor will take a partnership. They'll restructure it perhaps, but never actually join one. Angel investors, that's possible. They would get into a partnership.
So we're going to talk here pretty soon about qualified small business stock. I think it could be as a kind of a hybrid that you could start as like a limited liability company, make sure you have a business, make sure you really want to stay together. You want the ability to be able to reorganize. And then once you think you now need to have these other rounds of financing, you've reached the point, that's when you convert your LLC to a C Corp. If you can still meet the qualified small business stock exemptions, you might actually benefit from the way those rules work. So I wouldn't, even if you think your exit strategy might be, or need rounds of financing from venture capital, you might still start as a partnership. It would lengthen your holding period. It wouldn't be like from day one, but it might give you some more flexibility until you could sort things out before you're really sure what direction your business is going to go and what you needed. So that's it.
Okay. I'll talk a little bit about corporations and S corporations and C corporations and how they fit in and how they're taxed. So corporation is a separate legal entity from its shareholders. It is organized by filing the Articles of Incorporation in California, a certificate of formation in Delaware, and that sets forth the classes of stock, the name of the entity, what the indemnification rights are for the managers, and liability limitations for the directors. Corporation also has a set of bylaws. Bylaws are 95% boilerplate, but the 5% that's not boilerplate makes a big difference to the managers and to the shareholders. So there's a focus on the bylaws for each corporation. In a corporation, the shareholders, who are the owners, elected directors. The board of directors then elects the managers, and the managers conduct the day-to-day business. That's the corporate model.
You're on the next slide. We should move to slide one. There you go.
Oh yeah. So that's corporations. And now let's go on to the next slide, liability protection. Corporations provide liability protection, probably the best liability protection that you could get for the owners. That if they're not active in the business, they don't do anything wrong, they don't have any liability. The liability of a corporation that incurs liability, the liability stops at the corporate level, and then the investors don't have anything to lose except their investment, like the limited partners and limited partnership that Leighton mentioned. There's an exception to that. There's a possibility for in an egregious situation for a court to allow an injured person to pierce the corporate veil. That is, to go receive their payments from the shareholders and not just from the entity. And in a situation like that in California, it requires the corporation is not respecting the corporate formalities, and that the respecting the liability shield will work in injustice. Working in injustice, every plaintiff thinks that an injustice has been worked. So the only thing that the owners can really have control of is whether they respect the corporate formalities. What are they? It's having minutes, using the name of the corporation, using Inc. or Corp in the name of the corporation to show the world that they're doing business with a corporation, not a partnership, not a general partnership. Not saying my partner and I will have lunch with you on Thursday. You're my vice president and I will have lunch with you on Thursday, not your partner. So showing the world that there is a corporation. I tell people that it's like the cop that says, it's too hot today, I'm not going to wear my Kevlar vest, I'm going to leave it in my locker. How's that going to work out? And so it's kind of, somebody says, well, I have a corporation, but I don't want to put Inc. in the name. I don't think it sounds good. Or I'd rather talk about people as my team members rather than the officers of the corporation. It's like, you're not going to get the liability protection you're looking for when it really counts. So that's piercing the corporate veil. It's possible to have an agreement among the shareholders, but it's not required, like it is for a partnership or an LLC. It's not required to have a shareholders agreement or a buy-sell agreement. A shareholders agreement might say, here's how we vote on particular issues here. There's some situations where you can have a quote closed corporation, and we can tinker with the corporate requirements. We can have people be directors for life. We can have less than 3 directors. We can have a small number of directors, even though we have a large number of shareholders. Things like that with a shareholders agreement. With a buy-sell agreement, we would typically be saying, well, if any of us walks away from the business, here's how we get bought out. Here's how we value the business. Here's how we pay the price over time. Or if one of us dies, we'll have the corporation own life insurance to pay for our shares. Things like that. That would be a buy-sell agreement.
You might mention that bylaws and the shareholder agreement, those kinds of provisions that are in those agreements. When you have an LLC, they're basically generally, not always, but they're generally included in the operating agreement. So you have one agreement covers.
An operating agreement would typically have a right of first refusal provision. If somebody wanted to sell, they'd have to offer their interest to the other members, and probably be paid in cash, not over time. And that would be typical of an operating agreement. But if it was going to say, if somebody walks away from the business and their shares were bought, their LLC interests were bought back, I'd typically find that in a separate buy-sell agreement, even for an LLC. If it goes beyond a simple right of first refusal, I think I'd see it in a buy-sell agreement for an LLC. And the reason for me doing that is because they've got to have the operating agreement. They have $200,000 worth of litigation if they don't, and 5 years of litigation if they don't have an operating agreement. So just to figure out what their deal was. So they put their operating agreement in place and then work on the buy-sell agreement, and then amend and restate the operating agreement and say, hey, we have a buy-sell agreement. So that's how it goes usually for me. Securities laws, which Leighton mentioned, are incredibly important for corporations. There are exceptions to make that complying with the general securities laws is very, very expensive. It's like going public, but there's exceptions that don't require that. But it's important to meet the dot the i's and cross the t's for the exceptions. And the general gist of the securities laws is that everybody's a widow or an orphan, and they need the government to tell them whether they can invest in this company or not. And so the government's going to say whether it's fair and reasonable to issue these shares, and it's expensive to get the government to say that. And so there's exceptions, but I think the key to the thing is to remember that offering somebody an opportunity to invest in your company, or even issuing options to employees, those things are issuances of securities, and those things are going to involve the securities laws, and you've got to get them right the first time. And it can be difficult to get investors. Your investors are going to ask, did you comply with all the securities laws? If you say, what are securities laws? You're probably not going to get an investment from those investors. Next slide, please. No, not the slide. Text. Okay, you're right. That is the next slide. You're doing better than I am. So social purpose and benefit corporations are two kinds of corporations we have in California and lots of other states. The concept was Ben & Jerry's sold Ben & Jerry's ice cream to Unilever for a ton of money, and then they opted out, and all the nice things that Ben & Jerry's did, Unilever didn't do them all. Unilever didn't do them all. And so people said they had sold out, they're terrible. And Ben & Jerry's said, well, we had to. We had a public company. We had no choice but to maximize profit. And so laws came out that said, well, you can do something if you have this kind of corporation, a social purpose corporation, a B Corp, benefit corp, you could maximize something besides profit. And those corporations exist. B Corps need to be certified by the B Corp company. Social purpose corporations just have to have something besides a profits interest that's baked into the articles of incorporation and the corporate documents. The concern about using those, they're fairly new. They've just came out in 2011. They're fairly new. The concern is that a company that figures out how to desalinate ocean water and make it drinkable or something like that just has a major breakthrough. they're going to want to sell their business for a lot of money. And an attorney general might say, who watches over nonprofit corporations, might say, hey, wait a minute, that business was, those funds were supposed to be used for this nonprofit purpose. You can't just take the money and run and be rich guys now. You've got to use that money for a nonprofit purpose. And that is a concern, and attorney generals won't say, we won't do that. So it's a concern about using those entities. It's not a freebie. It's not a marketing freebie to use them. There's a possible downside. So let's talk about the taxation on the next slide of C corporations. We said there's two kinds of, well, first of all, classification. So if you form your entity under the corporation laws of a state, it's going to be a corporation for tax purposes. Leighton mentioned that if you had a partnership, you could elect to be a partnership or a corporation. But if you form your entity as a corporation, it's going to be a corporation for tax purposes. And the choices then are whether it's going to be an S corporation or a C corporation. C corporation is the default. C corporations pay their own taxes. And when they make distributions to the shareholders of their profits, their shareholders pay a second level of tax. So there's that double tax issue with C corporations. An S corporation, the shareholders pay the tax on the corporate income. There's no second level of tax when that money is distributed to the shareholders. That's the basic definition between the two. C corporations are in subchapter C of the Internal Revenue Code. S corporations are in subchapter S. So there's the C and the S. There's no way to remember it. Just you have to remember which is which. C corporations are not pass-through entities is the key thing. They pay their own taxes, which sometimes can be a good thing. We'll talk about that.
Yeah.
Because of that, go ahead.
I mentioned a lot of startups are what we call pre-revenue companies. I mean, they're not making any money. They may have no revenue whatsoever. They may have no income, but they're pre-income. So depending on your business model, some of this double tax and pass-through of losses, may not be relevant.
Yeah, if they have no revenue and no losses, it's not relevant. Yeah, that's not the relevant issue.
Except those losses stay in the corp and may get lost when never used, and your investors get capital losses on their investments. If you had a flow-through, pass-through treatment, the ordinary losses would go through, and even if they couldn't use them right away because they have these loss limitations, they're still ordinary losses. They've recovered their investment by claiming ordinary deductions. So there is a disadvantage of a lost business. You're better off with a pass-through than you are with a C corp.
If you have the loss and you have a change of ownership, you may end up with a very slow recovery, if you will, of your losses against.
Or greatly limited.
Yeah.
And so because of that, becomes that double tax on C corporations where they earn the money, pay tax, distribute the profits to the shareholders, and the shareholders pay tax again. Because of that double tax, companies like C corporations like to be sold as stock sales, not asset sales. A stock sale will be subject to one level of tax at the capital gains rates, whereas an asset sale by a corporation, the corporation is going to pay, sell its assets, pay tax, and then distribute this after-tax sale proceeds to the shareholders, who are then going to pay tax again. So we try to have a stock sale, and there's exceptions to that for qualified small business stock that we'll get to in a minute. Can we go to the next slide, please? So unreasonable compensation is an issue. If we have a profitable C corporation, we say, well, if we distribute out that money, we'll have a second level of tax. But if we pay it to the shareholders as compensation, they'll have one level of tax. It won't be as low as the level of tax on C corporation income, but it'll be lower than the double tax effective rate for double taxes. And the government can come in, the tax authorities can come in and say, wait a minute, that's unreasonably high compensation. Some of that compensation was really a dividend and was more than what the compensation was, the services were worth. And the IRS can do that, and it's always a concern when compensation gets high in C corporations. The tax rates for C corporations are 21%, just a flat rate, 21% for federal purposes, and for California it's 8.9%. So there's two flat rates that add up to about 29%. And for a company that's as compared to a flow-through entity, the income is taxed to the individuals at their their tax rates, which is 37% is the highest of the graduated tax rates for federal purposes, and 13.3% for California. So much different for the corporate rates. And then for the pass through, there's also a 20% deduction for qualified business income. That brings the rates down to about 30% for federal purposes. But still the 21% is lower. So when does it make sense to use corporation, even though it's subject to the double tax on distributed income, when the income is not going to be distributed, when the income is going to be used to pay off debt, like a leveraged buyout, take over a company, take on a lot of debt to buy it. The money's we're going to be using after-tax dollars to pay that debt. So let's pay the tax at the lowest rate, the 21% rate. We're not going to be distributing anything. We're going to be paying small management compensation, but most of the money is going to go to pay off the debt. And then maybe we'll build it up and sell it when the debt's paid off. So there'll never be a situation where we will be making distributions to the shareholders, making substantial distributions. Another situation if we have a business where we've got a tiger by the tail, all the income that comes in and all the investment income that we could get goes to build the business, and we just can't build it fast enough. We're not going to be making dividends to shareholders. That money is much better spent, used in the company, so that all the profits will be plowed back into the company at the 21% rate, better 21% rate than a 30 or 37% rate. So that's when a C corporation makes sense. For companies that are not plowing the money back in or not paying off debt, but they still are C corporations, the incentive is to keep that money there. Let's just build it up in the corporation. We might use it sometime. We might find an acquisition target, but let's just keep it here. Let's not have that second level of tax. And for a company that does that, there are two ways that the IRS could come in and say, you've got to distribute it out. And that is the accumulated earnings penalty tax, where too much income has been accumulated and there isn't any business use on the horizon. The IRS could say, look, we're going to tax that as if you distributed it, but we'll give you an opportunity to actually distribute it and get it out and pay that one level of tax. And companies do distribute it when they get to that point. And there's also a company that owns passive assets that an individual could hold, but they put it in a corporation to get the 21% rate. This build up the money, let the cash build up in there. The IRS can come in and say, no, you don't have any active business use for that. You've got to distribute that money out, or we're going to tax you as if you did. So it's not possible to, unless the income is going to be used to pay off debt or be used to grow the business, it doesn't really make sense to use a C corporation, because there's the unreasonable comp issue, unreasonably high comp, accumulated earnings tax, personal holding company that force distributions. C corps, like S corporations, can have various forms of incentive compensation, often stock-based. We could have vested or unvested restricted stock, where we issue the stock and say, if you leave in 5 years, within 5 years, you're gonna forfeit the stock, or some kind of graduated vesting scheme. We can have non-qualified stock options, where when you exercise the option, you have a bunch of ordinary income, but when you hold after that, you can get capital gain treatment if you hold for at least 12 months after that. We can have incentive stock options, where they can be, if they're held for a period of time, I think 2 years from grant and 1 year from the date of exercise, they get capital gain treatment. No ordinary income, no wage income when they exercise, even if the value exceeds the exercise price, but there can be alternative minimum tax at that point. And
one of the startups attract employees or key employees is to not necessarily offer them a high salary, but maybe a below market salary, and then an incentive stock option plan of some sort, so that they're really giving the shares of the company, or the growth of the company is really used as a kind of substitute for a higher salary that the startup can't really afford at a particular time that they're being growing.
And we talked about profits interests, and profits interests are kind of slicker tax-wise than stock options. But you have certain class of employees that they want stock options because their buddy got stock options and got rich, and so they want stock options. And when you talk to them about profits interest, their eyes just glaze over and said, stock options are not. I'm not coming if there's no stock options. So, and securities laws must be considered whenever we're using real stock. There's also a concept of phantom stock. That's just a cash bonus based on the appreciation and value of the stock over a period of time. That's just wages to the employees. But when we're using real stock, so that the employee can hold it. If you hold this more than 12 months, you can get long-term capital gain. When we're using real stock, we don't really have to worry about securities laws. Even when we issue options, we're issuing a security, and we have to be careful there. And California has its own rules as well as the federal rules. Next slide, please. Ease of restructuring. Before we get to restructuring, let's talk about putting appreciated assets into the corporation. You know, we've got some people that want to come in and say, hey, we've got a nice business going there. We'd like to make our business part of yours, or I'd like to make my assets, add my assets to your business and get stock of your business. So if we had a partnership and we did that, we'd be able to say, sure, put your assets in, we'll give you partnership interest. There's no risk of you having taxable income when you do that. In a corporation, the people who put the assets in, the assets that have a value higher than their tax basis, when they put the assets in, they don't have any tax when they get stock in exchange for those assets. If the people who put the stock in that round all control 80% of the company. So if you have somebody coming in and putting a valuable asset in for 25% of the company, and the 75% were the founders, they're not putting anything in now, then that person's going to have gain, and that's a more restrictive approach than with partnerships, and it's frustrating. Corporations, when they distribute appreciated assets to the shareholders, I'll take mine and you take yours. Let's split up. In that situation, that is generally taxable to the shareholder, and more specifically, it's taxable to the company. All the gain, the difference between the fair market value on the distribution date of that appreciated asset and the tax basis of the corporation, that is gain to the shareholder, gain to the corporation, and then when the shareholder gets it back, it's gain to the shareholder. So that double tax comes in. And if we have an S corporation where everybody's taxed on the corporate gain, everybody pays, all the shareholders pay tax, all that inside tax, and the shareholder receives it might have an additional tax. And there are such things as tax-free split-ups, tax-free split-ups, but they're phenomenally complicated, and which means that the transaction costs are very high to just know whether you're going to be taxable or not when you do this. And it effectively means that they're not available to Main Street companies, just Wall Street companies. Corporate groups, we can group C corporations together, and if we have losses in one, they can also have gains in others. It's very, very helpful. And California has their own rules about how to do that. Delaware has a franchise tax that's relatively low compared to the California 8.9% income tax. Is it 8.9, Leighton, or is it 8.96 or something?
8.9. 8.86, I think. Yeah.
8.86. Okay, thanks. So about rounded to 8.9%. So California has the 8.9% income tax, and Delaware has a franchise tax based on the stock that's the corporation can issue, which is a lower amount. But you find that when your Delaware corporation doing business in California is going to have to pay tax in California and Delaware. So we'll talk about using different states, but you might hear on the radio an ad for let's incorporate in Nevada, you won't have to pay any tax at all. Well, that's great if you're doing business in Nevada, then you won't have to pay any tax at all. But if you're doing business in California, you're going to pay California tax on all the income in California, whatever type of entity you have. So incorporated in Nevada means there's only one level of tax in California, but there's some other filings in Nevada too. So all you've done is made things more complicated for yourself.
Yeah, the Delaware franchise tax, it's a complicated tax to compute. I mean, there's on the Delaware Secretary of State website, they have a worksheet, and there's also the Harvard Business Service has a kind of calculator where you just put in the the key numbers, and out comes the franchise tax. In most situations that I'm working with, the franchise tax does not exceed $400. If you get a very large public company, then it's in the thousands, but that's a different situation.
Yes, it's just a hassle, like the filings in Nevada. I think there's a $300, $350 filing in Nevada, but it's just a hassle factor. So if it makes sense to use Delaware, it makes sense, but there's a reason not to too. So let's go to the next slide and talk about section 1202 and the gain exclusion so a corporation that's organized as a C corporation, more specifically a corporation that is a C corporation when the stock is issued to a shareholder, issued after September 2010. We can have, if the stock is held for 5 years and a bunch of other requirements are met, there's no gain when the stock is sold. No federal gain, still California gain, but no federal gain when the stock is sold. There isn't any other benefit like that in the Internal Revenue Code. You have to die to get a basis step up. You have to put, if you sell your stock to an ESOP, you have to have certain kind of shares. But the section 1202 gain exclusion is just an amazing thing. And so it comes up in choice of entity, because you can't say, well, I'll start out as an S corp, then be a C corp, and I'll get 1202. No, if your stock is issued by a C corp, you can use 1202, and if everything else falls into place. But if stock is issued by an S corp, you can't use section 1202. So
asset close to 50 million, is that basis or is that fair market value?
50 million is cash plus the value of the assets contributed to the corporation on the date they were contributed. So the maximum amount of gain that we can exclude is not unlimited. It's basically $10 million or 10 times basis. So if we put in more than $1 million, then we're using 10 times basis. If we put in less than $1 million, we're using the $10 million as the amount that we can exclude. And the corporation, now we get into the nitty gritty. There's no election is required. Unlike an S corporation, you need to make an election to be an S corporation. But the Q-sub, if you qualify, you get it. Excuse me, the qualified small business stock. If you qualify, you get it. If you don't qualify, you don't get it. So no initial election is made. The stock issues by C corp. There's certain businesses qualified. Generally, it's qualified. It's a qualified small business. Small in this case means less than $50 million of cash and the value of the assets when they were contributed to the corporation. Less than $50 million. The corporation has less than $50 million in assets, calculated that way from the date it was organized until the date the stock is issued, and also after the stock is issued. So if the corporation had cash and assets of 49.5 million, and you put in $1 million and brought it over to 50.5 million, you wouldn't get the gain exclusion. So it's got to be 50 million before and after the issue.
The new stock issuance wouldn't get it, right? You'd still
New
have
stock when the stock is issued, right?
Right. The other people still have their stock.
Yeah, the other people still have their stock. And so the tests are met at different, when people come in at different times, they have different 5-year holding periods, obviously, but they also have different, the $50 million test is applied when each one comes in. The businesses have to be active businesses. There's certain businesses that just don't get it. A lot of service businesses, farming or extraction activities just aren't going to work. So the corporation has to be active for substantially all the holding period. And so what does that mean? Substantially all the days of the holding period, all the quarters, all the years? It must be years. And so I think as a practical matter, when we look at these things, we evaluate it in terms of whether they meet this active business test for each year. And they also have to be a C corporation. So for substantially all the holding period. So I've seen companies that were C and then elected S and then went back to C. And if as long as substantially all probably means 4 out of 5. So if they were an S corporation 1 out of 5 years, they're probably okay because they probably met the substantially all test. Some businesses, they build it up and it's a good thing and they sell it within 5 years. But if a business is held for, if a qualified small business stocks we're talking about here, if that's held for more than 6 months but less than 5 years, it's possible to roll the stock over into new qualified small business stock, roll the gain over and not pay the gain and defer the gain and get a carryover basis in the.
And what does that do to the exemption amount? Can you increase the amount of gain that you can exclude? If you like, you have one company and you put it into 3 companies, isn't it issuer by issuer by issuer? So
yes, issuer by issuer by issue. So the
each
so the
10
new
or
corporation
multiplying
ask,
your 10 million.
So yeah, the new corporation is, you say, is this qualified small business stock? Is this new corporation or its total assets $50 million or less after I make my investment? So that would be applied at the investment for the new business, the rollover business. And the exclusion is very, very important. A lot of investors require that the corporation agree to do what it can to meet these qualifications. The Venture Capital Association has a form of agreement that could be used, but it's a big deal, and it's a big deal at the choice of entity. So it's kind of this monster complicated thing that needs to be digested to some extent when the choice of entity decision is being made.
So Bill, have you looked at what happens if you can't qualify? You know you're not going to qualify. Would you still be a C corp over an LLC if you're not going to get qualified small business stock? I mean, what have you looked at?
Let's talk about S corporations first, then get back to that one, can we?
Great.
So the next, can we go to the next slide about S corporations? Oops, we missed the C corporation takeaways. Okay, let's talk about C corporation takeaways. So C corporations have a low tax rate of 21%. Might not be that way after 2025, but it's that way now. And so with the 100% exclusion for a stock sale, it's pretty fabulous. Get a low tax rate on income, and then sell it no gain when the company sold. It's hard to get better than that. So for a company that's not making distributions, that's pretty attractive, and expects to sell in the short term. And angel and venture capital businesses, like corporations rather than partnerships. I've always thought that was because corporations go public and LLCs and partnerships don't. There was a period of time there when SPACs existed and LLCs were bought up by SPACs, and they retained the state LLCs and still were public. But I'm not sure how long SPACs are going to be around. But so that's just investors like corporations rather than partnerships. Corporations can issue convertible, C corporations can issue convertible preferred stock, which is what investors want. And they know how they work. And corporations, both S and C corporations, can engage in tax-free reorganizations with other companies, more specifically stock swaps. Either I'll merge my corporation into yours, I'll get some of the stock of your corporation, or I'll swap stock of my corporation for stock of your corporation, something like that, where the two corporations come together. The investors in the little corporation get stock of big corporation, and they have no tax, and they have a carryover basis, so they're still going to recognize the same amount of gain when they finally sell, but they defer the gain. So the ability to engage in a tax-free organization is something that partnerships don't have, but entities classified as corporations do. And we noted that we have to be careful about securities laws and tax laws when issuing options in incentive comps to employees of corporations. And now let's go on to S corps. So S corps are pass-through entities. The shareholders pay the tax, not the corporation, even if the corporation makes no distributions. We talked about a shareholders agreement or a buy-sell agreement early on when we talked about corporations. One of the things that would be in one of those agreements is, hey, I'm a minority shareholder. If I'm going to agree to this S election, you got to agree to make distributions every quarter so I can pay my estimated taxes. That would be a typical thing that a minority shareholder would require before making before agreeing to an S election. And the corporation has to make an S. More specifically, the shareholders have to make an election to be an S corporation, and all the shareholders have to agree. So somebody who says, "I don't think I'm going to ever get paid any distributions. This is going to be negative cash flow situation if I agree to this," they could they've got the corporation over a barrel, the corporation probably will agree to make the quarterly distributions if it can, and if corporate law allows it to do so. When we make an election, the shareholders and the shareholders' spouses who have community property interests in the shares also have to sign. And that's something we frequently see, is that the shareholders themselves made the election, but the shareholders lived in California at the time, lived in a community property state, and the spouses didn't sign the S election. We can fix that, and we often find ourselves doing that, fixing it right before an acquisition. There are a few corporate level taxes, particularly if you have a corporation, C corporation, that then elects S corporation status. There's some corporate level taxes that apply and has to be dealt with there, but they're generally manageable. Thing that's a tough one though is eligibility. Not every C corporation can become an S corporation. The corporation has to have less than 500 families, less than 100 families as shareholders. The only basically humans can own shares. Some trusts, but not all trusts. Some tax exempt organizations can, but they're going to pay tax on all the income, and also for the sale of the stock, they're going to pay tax, when that would generally be tax exempt for them. So there's some odd rules. One class of stock, so we only have common stock. We can't have convertible preferred stock for the investors and founders stock for the founders. So there's some issues, and if we violate any of those things, that second class of stock in particular, we can't issue shares to non-resident aliens. A non-resident alien is someone who's not a U.S. citizen who doesn't live in the United States. And so if we issue any shares that way, or the shares get into those people's hands through the operation of somebody's estate planning, we could terminate the S election. So the S election is fragile. It has a lot of benefits, but it's fragile, and the buy-sell agreement would often protect that fragile S corporation status. And S corporations don't pay self-employment tax on their. The shareholders pay self-employment tax. The shareholders pay employment taxes on their wages, but they don't pay self-employment tax on the flow-through income. So there's an incentive to use an S corporation to have a low compensation and have all the income flow through as profits, and then distribute that out. That'll avoid a 3.8% tax sometimes, and a 2.9% Medicare tax sometimes. And so there's an incentive to do that. And a lot of smaller S corporations, that's the reason why they're S corporations, to get that tax benefit. If they can't have zero compensation, there's such a thing as unreasonably low compensation, the IRS will come after them. California also has a tax on the S corporation profits of 1.5%. So if we're trying to maximize S corporation profits so that we don't pay a lot of employment taxes, we'll also end up paying California tax, and that reduces further the tax benefit of the S corporation, taking S corporation distributions and profits rather than wages. So with that, I think we'd like to go into the choice of jurisdiction. Before we go to the jurisdiction, let's go back to Clayton's issue. So when does it make sense to be an LLC? When does it make sense to be a corporation? So for somebody who has no liability concerns, somebody's going to be a screenwriter, or no liability concerns that arise from somebody else's action. So somebody's going to be a consultant. If they consult on nuclear waste, if they're wrong, terrible things happen, but it's their own actions, and they can't get protection from their own actions by using a legal entity. So somebody who has no employees is not buying products and selling them in commerce, that person might as well be a sole proprietor, because they don't get anything from no liability protection and no tax benefit from being an entity. So somebody who has two screenwriters who get together, they're not going to generate any liabilities that they don't know about, that aren't from their own activities. So they might as well be a partnership. But if we have somebody who's has a bunch of employees, things that employees do wrong, the employer is liable for. if the employer is a sole proprietor or a general partner, the employer has that a strict liability. They have that liability.
Yeah,
even though they
but
didn't
my
write it.
question was really about the qualified small business stock, because if you
Okay.
know you're not going to get a zero or you're going to get this exemption on the gain, then a lot of times it makes more sense tax wise to be an LLC. You've got other issues about getting rounds of capital. I mean, you can't get the financing necessary to grow it. But tax wise, you're usually, if you can't get the 0%, you're better off with pass on through of the income. You get capital gains treatment, et cetera. So at least under the current rate structure, unless you really are sure you're going to get qualified small business stock on exit, your tax liabilities are probably going to be reduced more if you're pass through than if you were a C Corp.
Yeah, there's definitely companies that
From a tax
that
perspective.
it makes sense to use a pass-through entity rather than a C Corp, but they need an entity for liability purposes. And then it's a tough choice. In those situations, if it's a brand new entity, it probably makes more sense to be an LLC rather than an S Corp, because the LLC has rock solid pass-through treatment. The S Corp, if they violate the eligibility rules, they'll become a C corporation and lose their pass-through treatment.
Right, it's much more flexible, easier for status.
But if it's a C corporation now, but they're not going to get the benefits of, they're not going to be a giant corporation, or they're not going to be bringing in investors, then they got a nice thing going, but they'll sell it someday, but they'd like to get as much cash out of it as possible. They might think about making an S corporation election. They can't become an LLC because that would be a liquidation for tax purposes, but they can become an S Corp and deal with the corporate level taxes that we discussed, and it might make sense. And some businesses, if they're looking to go public or merge with a company that is going public, might make sense to be a C corporation from the get-go. They have investors. They have investors want to take advantage of the 1202, the gain exclusion. That makes sense. So it's hard to say that for everybody one thing makes sense, and it's necessary to kind of walk through this. And I think what we're doing is helping people get sensitized to the issues, but I still think they're going to need to talk to a tax advisor to say, here's how does this affect my choice of entity situation. And so we've talked about choice of entity, a little bit about choice of jurisdiction, meaning which state to incorporate in. It doesn't make a difference. For a Main Street corporation, a lot of times it makes sense to incorporate in this or organize their entity in the state in which they live, because there's accountants there, their attorneys there, they know about that state, they know less about Delaware or another state, and it would be, they might as well just choose the local one. If they're not going to be doing business in other states, there's no real benefit to organizing in another state and having the hassle of filings in Nevada or Delaware tax. It's not a huge thing, but it's I'd say a lot of companies should be California entities if they start down in California. An entity that's formed in one business can change. It's generally tax-free to change, just a few $1,000s in transaction cost to change from one jurisdiction to another. To change from one type of entity to another, from C Corp to S Corp is easy, from S Corp to C Corp is easy, from corporation, from general partnership or limited partnership to LLC is easy, but you can't go from corporation to not corporation without having a liquidation and paying all the inside tax on it. And if it's an S Corp, and the inside and outside tax if it's a shareholder. Inside tax meaning the corporation's tax, outside tax meaning the shareholder's tax. And Delaware as a choice of jurisdiction for an entity that expects rounds of financing, venture capital companies, they're going to want to see a Delaware corporation, C corporation and a Delaware corporation. Delaware corporation has an established body of law that other states don't have for businesses and for corporations in particular. Every business lawyer in the country, they know about their local law and they know about Delaware law. And so Delaware law, as Bill Norman says, it's like English is the second world language. Delaware is everybody knows about Delaware law or know something about it. Delaware courts have a great reputation. The chancery courts have a great reputation for being more friendly to management than to minority investors, and also for understanding business. They're not family law attorneys who became have a business law case in front of them.
Use
quite
more
sure what to make of
slides, moved, a couple more slides were off.
Just change this.
Okay. No, we're a couple slides off. I apologize.
Keep
One more.
going,
Keep going.
keep going, right there.
Thank you. Thank you. Okay. Thank you, Clayton. Delaware laws provides more flexibility to limit fiduciary duties and to delegate responsibilities. Delaware law provides ability to access entity records, less ability to access entity records for the minority owners who aren't in management, and less ability of creditors to be paid from the assets of the entity. And with that, Bill Norman, would you like to talk a little about forming a Delaware corporation?
Sure. Do that. By the way, this is a very good slide. It pretty much sums up the whole story of whether you go to Delaware or not. Yeah, let's move to the deck that's formation of a Delaware corporation. Fred. Next slide deck. At the end of this. By the way, there's some good examples in here that Leighton put together, but we don't have time to go through them. But the answers are there. There we go. All right, what I did here, and it's really just a start. I took my kind of in-house checklist, did little annotations of it. What I intend to do is listen to all the webinars in our series and then further annotate this checklist. So it basically has the major points that are being raised in the various webinars. But let's just go through this if we can. Go to the first slide here. I put together, I guess, how many documents do we finally end up with here? 45 documents, I guess. And I use this as a kind of way to teach how you organize an entity. Most of the items I'm talking about, with some change in terminology and perhaps agreements that are kind of consolidated in the case of an LLC, are the same. You can have an LLC that looks like a corporation. You can have a corporation that has kind of partnership type characteristics. And of course, a limited partnership is, it can be made to look like an LLC in some sense. But what do we start with? Well, on our first webinar, and I think we nailed it pretty much in that one, is we need a business plan. If I'm the organizational attorney, I like to know, where we're going, what are we going to do, and where we're going, and the things that Leighton mentioned about allocation of profits and financing and that kind of thing, and a final exit or succession or continuation strategy when the business is in a more mature state. It helps in developing the documents, because documents really reflect what the company is going to try to do. The first line there is just an incorporation questionnaire. Some people are concerned about the name of their corporation because they're going to use that as a brand. So you don't want to form a corporation and find out that you can't register the brand as a trademark, or it's already used in a number of jurisdictions. So I usually start with the brand name, and then we try to see if the corporation can use that name if it's available. And on the next slide here, this is the certificate of incorporation. In California, we call them articles of incorporation. If it's an LLC, it's articles of incorporation. If it's an LLC, it's articles of organization. That's all really the same thing in a broad sense. What I did here is to take a look at what I call my typical kind of startup. So we issued 10 million shares. We authorized 10 million shares, and the par value is 0.0001, or even put another zero in there. By the way, I looked at Apple 10K, and they have, I think, 3 zeros in front of their, I think the 4 they have, because they must have started off as a startup and they wanted to have a low par value. You don't issue all of the authorized shares because you want to retain a pool for your employee stock plan early on. So you usually issue 6 million or 8 million shares to your founders in whatever your allocation plan provides. Go to the next slide. I took just a little example here. I'm not going to explain how the franchise tax works in Delaware, but if you have 6 million shares issued out of the 10 million that are authorized, you have $500,000 of assets on your 1120. That's your corporate return. Then the Delaware corporate franchise tax under the so-called authorized share method is $85,000 and change. And Delaware has a tendency to send out, a statement with this large number. But if you use the assumed par value method, which I'm not going to explain, but it's not all that complicated. It's not worth spending the time on it. The franchise tax is $400. So you want to be sure when you do form a Delaware corporation, you have your par value properly done and your authorized shares done, so you can get the lower amount. Otherwise, it's going to be a shock, and you have to start with a new corporation somewhere. Can you go to the next slide? What are certificates of organization of good standing used for? Well, you can't really open a bank account or conduct business under states unless you have a good standing certificate. So you have to order some of those in advance. Then the incorporator is the one who forms the company basically, signs the articles of organization or certificate of organization. They typically appoint the initial directors and adopt provisional bylaws. An LLC, the statute doesn't usually provide for that, but I use the same mechanism, if you will, so I can get additional, who the members are and also who the managers are. In the partnership area, you don't really have that. You have a certificate of limited partnership, but the limited partnership you wouldn't have this kind of document. We'll go to the next slide. The bylaws are pretty much standard in most corporations that are organized in Delaware. It's really just the governance mechanisms. There are special voting requirements that are needed. You want to be able to have meetings virtually and have remote participation. But if your bylaws are up to date, whatever form you're using, then it should cover those items. The kind of bylaw type provisions you find in the LLC is going to be in the operating agreement, some section of it, and partnership is going to be part of the partnership agreement. You might ask, where do you get some of these documents we have here? If you actually had to have, hire a lawyer from scratch, develop whatever the original documents here that provided, the fees would be enormous, with respect to a startup. But luckily, a number of law firms, several law firms, not a number, really, several law firms that do a lot of startup work have online for no charge sample documents that are acceptable in the financing market, in the VC, venture capital markets, and the other angel market as well. And Cooley LLP is one, and Oric, I think it's ORRICK, is another. Morrison Forster, that's one as well. Just type in the name of the law firm and then put startup forms, it will come up. And you can't just use them, without looking at them or having somebody read them, because they have some complex provisions. But they basically represent what is kind of standard or market, at least in Silicon Valley. So I usually start with those for reasons of economy, and also because they're very good forms. They've been worked over, a number of times by a number of lawyers and gone through a number of deals. And so I think they're a good place to start. Go to the next one. This is once you get the entity formed and the directors appointed and bylaws appointed, then you have an organizational consent where you basically appoint the officers, authorize bank accounts, designate principal place of business, which is not likely to be Delaware in most cases, and authorize, importantly, the issuance of stock to the founders. And we have another document that deals with that, but that's important. And adopt accounting period and method. There's some other things that go in there, but that's kind of the basic provisions. Then the next slide, go one more. Well, let's go to that one. These are ones that are pretty routine. You need to get a taxpayer ID number. You can't do anything in terms of opening bank accounts, or filing tax returns or whatever, unless you have an ID number. So the accountant often does that. It's not a big deal. In-house people can do it. The incorporated attorney can do it, but somebody's got to do it. That's sometimes the problem with that's why I use a checklist. If somebody says, well, I can do it, in-house, then fine. But then we want to be sure that it actually gets done. The bank opening documents most people are familiar with, and that normally requires a good standing certificate that we mentioned earlier. The banks have their own resolution, which usually whoever's opening the bank account just signs and says, we've adopted this resolution. But technically it should be then attached to your organizational consent. By the way, we use consent and not meetings. You can have an actual meeting, face-to-face meeting or a virtual meeting to do your actions of directors. It's usually more convenient, especially in COVID times, just to use the consent document, which can be done in counterparts. Okay, the next slide. If you're going to conduct business in other states, which means you either have an office there, one or more employees, or significant revenue, assets, or transactions, you may need to qualify to do business in that state. States are getting very aggressive in their laws and regulations and in their enforcement with respect to corporations not organized in the state, doing significant business in the state, even if they don't have a physical presence. And so that can be.
What are the consequences if you don't, Bill?
Consequences is that you owe the tax that you didn't pay. You'd have a penalty probably, and you'd have interest. And I have a corporation that I advise, and we did years ago, we did a study as to where they should qualify, and they kind of put, they qualified in those states and they kind of left it aside. Now they've got another 20 or so states where they should have qualified for the last 10 or 15 years. So now I have to figure out, can they get some kind of.
Isn't there contract voidability and failure to maintain? You can't maintain lawsuits and other things if you're not qualified.
Yeah, you can't. Yeah, that's true. You can't sue anybody in those states. So it depends on your business model. But I think, the major thing I think is the penalties, which can be enormous when you're talking about quite a few states and a number of years, and they're not necessarily proportional to what you're doing. If you did enough business to have to qualify, then you're likely to have a penalty, which will, after a number of years, will really mount up. And as mentioned here, if you're a Delaware company and you're basically doing business in California, then you've got to register as a foreign corporation. And that brings up the issue that we talked about earlier, that you've got the kind of double registration and agent for service of process fees that are there. So in Delaware, you'd have let's say the $400 of franchise tax. You'd have to hire a registered agent. It could be a couple $200, let's say, although it's a different number of the company. So you got about $600 going there, and then you got to also register in California, which is a minimum of $800 plus whatever the tax is in California. But it's if you're not making money, which is what a lot of startups are doing, now they don't have net income, then you're going to have the minimum tax in any event. Okay, next slide. Sales tax registration, which I have here, is important. Customers, same kind of issue we just talked about a minute ago. With the next one, these are just kind of routine things. You have annual reports with the Secretary of State, or sometimes they're biannual in the case of LLCs. These should be calendared. We talked about the calendar later on. There's workman's compensation insurance if you have employees. Just leave it there. So the next one. This is a very important document. at least the companies I work with, this is the agreement between the corporation and each investor, basically a founder in most cases. And it contains the third item there, what I call a vesting schedule. And it's common for the founders to be subject to a vesting schedule, which means if you, let's say you have several people who get together and have this form this corporation, and one person gets tired or has another venture they want to work on, and if you didn't have a vesting schedule, they'd end up with, let's say you had 3 people, they have 33% of the company, even though they do nothing. So you have to have a vesting schedule, which typically provides, as I say here, 1 year cliff of 25%. So if you don't make 1 year, you get nothing. If you make 1 year, you get 25%. Then the remaining 75% typically vests monthly over the next 3 years. So it takes 4 years for the founder to get the founders to get the, or each founder to get the full amount of their stock. This usually is in substitution for what we call a founders agreement, and also a shareholders agreement. So you can have all of these agreements, a well-drafted stock purchase agreement, which by the way is in these libraries that I mentioned earlier, is really a substitute for what you would put in a founders agreement, which is kind of a formalization of your business plan. The shareholder agreement being the types of things we talked about with respect to S corporations earlier. Okay, the next thing is the founders agreement. This stuff would be in the stock purchase agreement, but the equity split and termination and the vesting schedule are the kinds of things you have in there. Next one, please. This is another important document. This relates to pre-organization intellectual property. And once you have the entity, all founders, as part of the stock purchase agreement obligations, would assign their pre-organization IP that's within the scope of the business. I mean, there may be founders who have lots of their areas they're working in, but the area that relates to this particular startup company, all that IP should be transferred to the entity. And the question is, why is that? Well, when you go later down the road and you try to raise money, your angel investors or your venture capitalists or whatever's going to help you with the funding wants to know who owns the IP when they do their due diligence. If you don't have this agreement, then it's going to be maybe one of the founders has it, the founder that's inactive, and it's going to cost a lot of money to maybe get him to sign off or her to sign off on the assignment after they've left the company. Okay, let's go to the next one. This is the securities formality, which we will talk about in the fall. But basically, when you find an exemption, which is usually available in these formation of these closely held corporations, you then have to file a notice with the California Department of Business Oversight, or any other state that's required. I have one company that's California and New York, and New York has their own kind of exemptions, which require you to have a federal exemption, which requires then the particular type of federal exemption to actually file some paperwork with the feds. And California doesn't require that. It usually just use what they call a 4.2 exemption, which is a closely held private transaction, which doesn't require any filing with the Fed, with SEC. So the next slide. The second point here, the cap table, we're going to have a session that's going to deal with this. This is basically a spreadsheet where you keep track of your issuance of stock, liquidation preferences, restricted shares, preferred shares, convertible debt rights, stock options, which this is not on there, but should be. And what you do is that table will allow you to convert to what is the fully diluted value, if you will, or voting interest of the a particular group of shares or per share on a per share basis. There are companies that even keep track of it for you. Online, this is one of the law firms I mentioned, has a little sample spreadsheet, but it's better explained in one of the texts that I suggested that you read where they explain how it works. It's a kind of mathematical thing. You have to be good with your Excel spreadsheet to make it work. But so sometimes it's better to sub that out. Go to the next one. Copyright and trademark registration, I understand, is not required, but generally advised. We'll find out when we have our IP session. Copyright is, if you just write something that's novel, it's going to be yours, and people can't copy it, but you may want to register it. Trademark is just the source of whatever your product is. And it can be important depending on what your product is. Patent applications is a formal procedure with the patent office. And
so Bill, do you recommend that any searches are done to make sure that these trademarks and trade names, service marks are available?
They go back to the trademark. Yeah, it's I would say at a minimum, you want to search the existing databases to see if the name that you want to use has been already used, and especially if it's been used in the same general industry category or business category. If you hire somebody to do it, then the attorney does a search, and they hire the company that does the search, and then you end up with something that's probably pretty good in terms of whether your name's going to be available or not. It's not all that costly, but it's not hundreds of dollars, it's several thousands of dollars to do it. So some startups defer that. I think it's not a good idea if you have a brand that you really want to develop to let that particular item kind of be deferred. Let's go to probably the last time here, very important, non-disclosure agreements. This is basically that whatever you learn about the company because of your relationship, you can't talk about. I remember a number of years ago, I went to it's now a very major company. I went just to do a kind of presentation to see if I could get some tax work. And immediately I was given a non-disclosure agreement to sign. So I can't ever talk about this company. I don't remember what it was. The copy has been, buried in my files somewhere. But basically, anybody that's going to come into your office, that's going to try to sell you something, invest, be a contractor, be an advisor, certainly officers and directors should sign a non-disclosure agreement. Now, with certain investors, they don't like to do that because they don't want to have to kind of figure out, who they talk to about learning about a particular, feature of in the industry. So what you do with that is, if you got somebody who will not sign it, then if you got to give them information, you got to be very careful what information you give them, because they're not legally obligated not to disclose it. And the next item is another very important item. This is post-organization or post-incorporation development of IP. And it can be employees, it can be the founder themselves. And so anybody who's, and maybe most employees that are working on the technical side of your business and not just doing just administrative work, should sign this. It should be a condition of employment. It's called the Confidential Information and Invention Assignment Agreement, but it's not just inventions. It covers, all types of IP. Some people call it the Proprietary Information Agreement, PIA. It's a little easier to say than whatever CIIAA is, but people in the Silicon Valley are able to roll those off their top of their head, top of their tongue, but I'm not able to do it yet. Next slide. Officers and directors often want an indemnity agreement so they're not liable for anything they do within the scope of their employment, provided it's not, illegal or gross negligence or something. 29 really should be discussed later when we talk about employment in the employment webinar, but all employees should be given an offer letter, which basically sets out the terms of their employment. It's not really an employment agreement, although it has the same effect. So at least there's some record as to what you promise in terms of vacation pay, annual reviews, hours of work, etc., and the type of work even. And I didn't put in here, but we'll add obviously an employee handbook. These are kind of standard items that can be found on the web. Obviously, have to customize it to your circumstances. The employment lawyer can do it, and then depending on the number of employees you have, it may be worthwhile to have an employee handbook that's been vetted, if you will, or even developed by an employment lawyer. So employment agreements, I have everybody who's an officer or key employee be under an employment agreement. It's salaries and termination provisions, for instance.
Bill, since we're on the indemnification slide still, do you recommend that they get D&O insurance, directors and officers liability insurance, in lieu of indemnification, provided indemnification?
Yeah, that's usually you authorize that. I guess that's the question whether you want to do it. I think it depends on the business whether you really think there's a major risk there, but I think it's a good idea. Let's put it that way. Although I have lots of companies do not have that kind of insurance, but you have indemnification. Now, indemnification may not mean much if there's not many assets in the company. So that's that may be hard to have somebody come on as officer director if there's not insurance, because there's nobody to, for some period of time at least, to pay the any claims that might come up.
And the indemnification is made by the company, not by the founders, right?
Exactly. No, they're not guaranteeing what the company is indemnifying. It's my experience. So we should go to the next one here. That's what I just talked about. A stock option plan. Go back. Yeah. This is really the currency in the startup community, is how to get good employees without paying more than you can really afford, and certainly in the early years. You do that by offering stock options, and we'll have a session just on stock options in the fall. It has obviously tax implications for sure. The agreements that establish it that have special features, and there has to be a securities exemption, which is available in most situations. There's a specific exemption in the federal statute and in California. And then another one here. If you have advisors, I would again formalize the agreement with the advisor, get the non-disclosure agreement from them, and if they're actually developing IP, then get the agreement that transfers that IP to the company or says it's for the company. Engagement letters from lawyers and accountants. I don't have time to talk too much about that. One thing to say is startups don't like to pay legal fees and can't really afford it up front, but lawyers like to get paid. So you have a natural conflict there. So typically, not always, typically what's done is the hourly fees for an attorney are heavily discounted in the early years until the first major financing, however you want to define that. And then it becomes the regular rate, whatever it happens to be. I guess if you don't get fired, it's always a problem. If somebody really wants to keep their fees low. Some lawyers, we have fixed fees for some of these agreements that we're talking about. If you're really just using a form off the internet, you may want to just charge a fixed fee to customize it to the particular company, whatever that would be. which would be considerably less than the actual drafting cost from scratch. And if you're dealing with the companies in various locations, you don't have a choice of law. You want these, enforceable under California law. Okay, let's go to the next one. These are pre-seed and financing. These are very early stage financing, typically done by a promissory note, because there's no way to know what the value of the company is at that point. They can try, but so basically you want to avoid evaluation if you can. It makes it easier to issue, by the way, stock options if you don't have a value that's been determined by some financing, if you will, because of equity being issued. We'll mention the SAFE, which is a simple agreement for equity. It's kind of the structure de jure, if you will. The contract really to issue equity at some point, there's been some event that would then trigger the issuance of the stock. It has some features of a option or warranty, but it doesn't have any interest being paid, and it doesn't have much in the way of rights other than to get equity if some series of events occur, whatever they happen to be.
So Bill, do you think that you get a tax holding period for qualified small business stock if you have a SAFE? Or do you count your 5 years from when the stock's actually issued to you?
I don't know if it's carried over or not. I think it's generally kind of equity, but I don't know that you get a carryover. That's what there's going to be an exchange, right, of the SAFE for whatever the stock is. So I guess it could be kind of recapitalization possibility. I don't know. It's
So if you want to be certain on 5 years, you wouldn't get SAFE, you'd actually get stock, right?
Okay, finish up here. Okay, and the next slide. Investment letter is really a securities compliance letter. We won't talk about that right now, but it's just basically establishes that there may be a security involved here, and that the lender is not intending to distribute the stock that they may get. Founders, I suggest that they don't make additional contribution of equity, but should make loans. Otherwise, you have a very complicated cap table, which later investors may not like.
They do on interest. You actually have interest to be accrued and be paid.
You put a low interest, but nobody ever pays interest on either the pre-seed loans or the loans by founders. It just kind of sits there, and then when it's finally canceled, if you will, then the interest is paid, which is generally down the road when there's a major financing, and whoever it happens to be says, let's clean up, all of this stuff, and it will pay off all of the lenders. So that's when they get paid, or they get stock. Have a conversion feature, if you will. The next slide. These are the leases and licenses. We'll talk about next in the fall. One more slide. Okay, this is what I'm suggesting is a rolling compliance calendar. I haven't mentioned everything on here, but somebody should be responsible for making sure that all of the kind of annual or periodic, sometimes they're not annual, they're quarterly, all of these statements and filings with the government, appraisals for stock options, which is what a 409A appraisal is, are done. And it's easy in almost any company that's going to lose track of the compliance. I mean, the tax people keep track of their tax things if they're tax people, but often the controller is not, primarily worried about tax, but more keeping track of expenditures and cash flow. So somebody should do that. Then next item, the next slide, this is the last one. This is the key thing. And we talked about, what's the due diligence that your later investors will be requiring. Well, they want to see a data room. The data room is no longer a physical place. Obviously, it's a virtual room with folders, and the folders have these various documents that we've been talking about here. and probably annual financial statements, annual Secretary of State filings. You can't clutter it up too much. You wouldn't have original source documents from that are used for accounting purposes, like vouchers and things like that. But you would have the kind of final financial statements. And you need an index, and you need ways to block access to particular folders. Because you have somebody come in, they say, well, I'm thinking about lending you money or doing a contract, development contract with you. You may not want them to see this entire data room. So you just give them the documents you want. So you need somebody who knows how to set up these folders so that you can block a particular folders from being disclosed or access to particular folders. So that I think gets us to 6 o'clock. Let's see if we've got anybody that wants to talk to us about something that's no, it's more about moving the slides and that kind of stuff. So I don't, maybe has no questions. I mean, I think our kind of takeaway here, I invite Bill Layton to talk about it, is I think you really have three, in most cases, three choices. An LLC, an S corporation, or a Delaware C corporation. I mean, there's variations where you might have other choices. And then if your goal is to get major venture capital financing or major angel financing, then you need to seriously talk about or consider the Delaware C corporation. You may want to do one of these conversion situations where you start off with a pass-through and then either incorporate or terminate your S corporation election. But I think that's where you go. In terms of documents, if you don't do a lot of these documents, you end up with a company that is going to be very difficult to finance or to sell. You may have some resistance from key employees when they see the kind of shambles of what you've got here. You may have a great product, but nobody knows who owns it, owns the underlying IP. You may have a lot of unhappy employees who are willing to sue you because they think you promised them something they never got. And so it's important to keep your legal house in order, so to speak, and to have documents that are organized and can be accessed easily, and to have a complete set. I mean, there's one case I have is I have a corporation, an S corporation. It's been an S corporation for, let's say, 40 years. Through whatever the change was, I think it was 87, or I'm not sure when but anyway, they had an S corporation through those changes. And I said, well, where's the S corporation election? Which normally I would think would be in the minute book. Not in the minute book for whatever reason. I said, well, let's go to the accountant. He says, well, I've destroyed all the files that are more than 7 years or 10 years old or whatever, and the election must be in there. So I never destroy a client file. I may give a record book to somebody or something like that. But so I found the S corporation election with some difficulty. You get a confirmation from the IRS. It would have been a very difficult situation if you had and they're thinking about having a sale or some sort, maybe a stock sale, a stock exchange. And the due diligence would have found that right away, and it would have resulted in then the company having to do some kind of a election, a reorganization to push the liability for the possible C corporation taxes that may have been due for this S corporation. We can't prove it's an S corporation onto the sellers or the client, the target corporation. And all the assets come out without the liability. There are ways to do it, but it's going to cost the seller and the owners of the company some dollars if we had not found the S corporation election. Okay, any parting
Bill, we had a couple of questions. One person asked, is there a reliable place to find an LLC operating agreement or an LLC agreement? And my thought is that there isn't, because it's so customized for each deal that a form is going to be great for an attorney who knows what they're doing, and for somebody else, it's just dangerous.
I mean, I did my own, so but the California CEB book for California LLCs, I think, is a good one.
That's a good place.
There's a LLC. Oh, I know what it is. There's a LLC. I'm trying to think of the name of the company that does it. It's a handbook that Phil Gelsma does. I'm not sure what it's called now, but anyway, it's a 2-volume book on LLCs, and it has an electronic library. In the electronic library are various operating agreements for various states. So that's
Gelsma is Gelsma. Phil Gelsma is the author. Someone wants to look that up. Someone else asked about what about having an LLC that elects to be an S corporation or C corporation? And Leighton, did you want to talk about that?
Yeah, sure. I don't advise it because people see LLC and they think it can do anything. You can have capital accounts and you can split profits. And so I know it can help in terms of governance if you're worried about piercing the veil. It's like some people do it because you don't really have to have shareholders and officers and directors, and the formalities are less. And so that's why people do it, because you can have everything in agreement, almost like a closed corporation. But I don't like it when it's too contrary. Most people forget the tax treatment, and they'll do things that will blow the status, particularly an S corp. So I don't usually advise it.
I'm concerned about cocktail party advice. It's like, what kind of entity do you have? An LLC? Oh, you can have a profit.
So I usually, when I get corporation per se, if I'm going to really be a corp, that's my, with the caveat, you got to, have more corporate formalities, but I generally think that can be done. I wanted to at least add a point. I know we have more questions, and that is that the tax laws change all the time. Our discussion today is based on law today. If the Build Back Better Act had passed, our discussion today would have been entirely different. So it's really hard to say, if C corp rates go from 21 to 28%, if you lose the qualified business income deduction, if the qualified small business stock is only for people with incomes under $400,000. The carried interest legislation has been proposed. I mean, we're talking about capital gains rates being taxed up to ordinary income rates, a complete changing of everything that we said today. And it really is just a matter of, what Congress may or may not do in the future.
Senator Wyden has I guess, a discussion draft of some changes to the partnership law, or major changes to the partnership law.
Yes, September of 2021, and it's drastic. It's a huge change to subchapter K.
And he's chairman of the Senate Finance Committee, so he's not just some average senator. He can push some of these things if he so inclined.
Mm-hmm.
Yeah, we didn't. I guess the other thing that we didn't talk about is what do you do with either foreign investors or companies that have foreign I'm calling operations, people that are not in the U.S. And typically, if you've got a foreign operation, I put it as a subsidiary of whatever the U.S. company is, and not the other way around, because your financing is coming from the U.S. typically, anyway, not always, but typically, and so I make them a subsidiary. So like a Delaware company with an Israeli subsidiary, for instance. Now there's some places where we have employees in some of these companies, like Bulgaria or Northern Macedonia or something like that. So we don't usually form a subsidiary in just every place that happen to have an employee. But you do have the issue about are you doing business in that particular jurisdiction, or do you have what we call a permanent establishment in that jurisdiction, and are you subject to tax because you have an employee there? And you have the same issues when you have remote employees working in the U.S. because we have people, that decide they're going to live in Arizona or Nevada or Wyoming or Washington, or Idaho, and all over the place. And the question is, is the company doing business there? Are they treated as employees for California purposes, or do you use the law of wherever they are? And do you have some withholding responsibilities with respect to California, with respect to the place where the people are located? And so those issues are being sorted out, but it's very, very state specific, if you will, as to what the answer might be.
And Bill, what about the investor from outside the U.S. in the U.S. company?
I'm saying, what's the question about you?
Somebody has an investor from outside the U.S. Do they just take their money? Is it easy?
Well, if you got a U.S. person setting up a foreign company, unlikely that they would avoid U.S. tax because of a provision we call GILTI, Global Intangible Low Tax Income, which basically sweeps up most income earned by a foreign corporation that's controlled by U.S. persons. So trying to plan to avoid tax by going overseas is not usually going to be a good strategy. I mean, companies like Apple and Facebook and others are now not able to get their 1 or 2% effective rates, or 6 or 7% effective rates. Amazon's another one, because of the changes to the law that came in 2017. So if it makes sense to be overseas, that's fine, but it's usually not going to be because of avoiding U.S. tax in some way. It's very complicated. I mean, I had some startup people come in maybe a few years ago, and they wanted to set up in the Cayman Islands, and so we kind of went through how they could do it. They probably wouldn't be able to save much, but I said, well, who's going to go to the Cayman Islands? He says, well, there's just 3 of us. So nobody's going to go to the Cayman Islands, but they're going to have a company in the Cayman Islands. I said, well, I don't think that's going to work, because there's no substance to what you're doing. You can't just have a paper company and allocate income, willy-nilly, if you will, because you've incorporated a company there and hired some lawyers or accountants to kind of act as directors and managers and so on, if there's nothing going on there. So foreign tax planning for startups and even for U.S. companies is, if you're trying to run a deferral, not paying U.S. tax, is pretty much gone by the 2017 Act. It will be really hit heavily if the Build Better Back Act ever passes or is passed, at least in its current form. Anybody else? We got it?
We got it.
Okay, well, thanks everybody for attending.
Thank you.
Yeah, thank you.
Thank our panelists too. Ellen and Layden, I think, did a great job and a lot of work on the outline. And I think we'll probably put that into our own data room for people attending this conference. It'll be on the website at some point. Somebody asked when does the recording get posted? It's usually not very long time. It goes onto YouTube fairly quickly. I would say within a week or two. So it is possible to watch this over and over again, if you will, if you're so inclined. All right. So good night, all.
Good night.
Good night.